IPR laws and their management related staff. It's very vast topic. I think definitely I will stick to that particular time and we will cover various aspects of the patent laws and how it's managed. What the start of the now see. So beginning with every land has a statement. The only thing that keeps alive our brilliance, the only thing that protects our brilliance is the patent. So brilliance, what we mean by brilliance? Now see, there are two types of assets. There are tangible assets and intangible assets. What do you mean by tangible? Tangible means we can able to show the results. Okay, this is what the asset of this. Okay, whatever buildings, all those things are tangible assets. So it can be protected by the law. We are having a constitution and like laws to protect those. Now, what about intangible assets? Intangible assets are both assets be able to that whatever our creation of the mind is an asset of that. So how these intangible assets are going to be protected? So definitely intangible assets should be guarded. So whatever the creation of your mind is going to be art or the creation of your mind should be protected. So those is going to be protected by means of some kind of fence. Some kind of fence. You have to put the fence around your intellectual property. Now, how do you do it? Patent is a history of a patent. So, I am just going to be checking that terms of and for our country, there is a Patent Act 1970 and with that act there is a rule, Patent Rule 2003. So what do you mean by act and what do you mean by rule? So act is something that we can say the act is just take an example. नीचे होते हैं तो थोड़ा थोड़ा ट्राई किया तो इधर में अंदर तो what kind of say punishment has to be given to that particular person is different according to his crime. So there are various rules and there. So that is how. So we must aware about the act and as well as the rules. Now, next is what we will also learn at the end of the lecture. So only few objectives now. What is patent? You will go to assessment about the Patent Act 1970 and Patent Rule 2003 and exclusive right offered by the what right is offered to you for your intellectual creation, for your intellectual creation. So patent deals with innovative products or processes. So for what patent is granted? So it is going to be granted for the product and what could not be patented. There are two views. What can be patented, what cannot be patented. So if you know what cannot be patented, then you can able to understand what can be patented. Okay. So history of patent is very it's from BC around there are say Chinese pots there are, and so many things are there about that history. So I am skipping those slides because of our time constraint. So we need to focus on main aspect. Then how the patent system is supported in US and economic growth. So we know that economic growth is aligned with your patents, because whatever we are creating from our mind, we are making it in a tangible assets. We are creating, we are manufacturing. So whatever our mind thinks, we will convert it into an tangible assets. Tangible assets like products or processes. So what processes? Making and research out of plant or anything. So these are what processes. But those are going to be again an limitation in our Indian regime. So IPR status in India from 2000 there is one trend, there is increasing trend in India about patentability. Before that we are very sluggish about so to get the patent and all those things and stuff like that. आपण त्यामध्ये इंटरेस्टच नाही ठेवले. त्यानंतर आपल्याला पेटेंट ग्रांट्स पेटेंट इन इंडिया हाउ मच देर आर पेटेंट्स फॉर इंडियन resident, non-Indian residents and abroad. Some persons from the abroad. Person is a definition. Person means not a single person. Person might be going to be an institution. Institution can be treated like a person in a law, aspects of the law. I hope you are getting those things. Then, what do you mean by the patent? So, the patent is an originated from the Latin word that is patent. Having means to open, and each national government can grant an individual institution or organization for these inventions. Each government is having their policies to grant that to certain kind of an say patent to that invention. So, moving towards that. In our India, 1970 Patent Act 1970 is enacted, and by this act, the Indian government can issue a patent. And Rule 2003. There are various series of amendments in Patent Act 1970. Till now, I think there are 7 amendments in various acts and rules. Okay. So, how many types of patents are there? So, already as we have discussed, the patent can be granted for the product or the processes. But only thing is that utility patent will not be provided in India. It can be provided in rest of the world. Patent, just like the product patent, process patent, we can able to get it, but not that. Now, purpose of the patent you already know. Then, what is the purpose of the patent? Say, purpose of the patent is to protect that idea, whatever we have created. Now, we can say every idea should be converted into either the product or the process, but it should not be overlapped with others' idea or processes which will already being in existence, which is already being in existence. So it's an say intangible asset now. So how that fence is provided? So fence is going to be provided in terms of words. In terms of words. For example, see, there is one case law, TVS versus Bajaj, for twin spark plug. So that it is a claim of that TVS that twin spark idea or that patent is invented by their company. But Bajaj claim first and they are manufacturing. That still dispute is going on. But only thing Bajaj claiming due to the angle between two spark plugs. So I think Bajaj claims that TVS has not mentioned about angle, and that's what the advantage is taken by the say Bajaj, and that's how they claim. So many things are happening due to intangibility. So this intangibility should be protected with a particular certain words. So words are just like a phrase to those ideas of the product. Okay. Say importance of the patent defined. Say what can be patented. What can be patented? So it is given in Patent Act 1970. 21J states about the three things. 21J state about the things: novelty, then innovative step, and utility. These three things are required. Novelty, then innovative step, and utility. Utility, that is what industrial use. If any of one is missing, then product or process cannot be patented. Product or process cannot be patented. Now, see, what is the check then about the novelty? Novelty is what new means. Newness is a new means which is not existing in previous knowledge. Not existing in previous knowledge. It means not means surprisingly सगळं एकदम येऊन खाली पडलं आणि हे ते काही न्यू आहे असं नाही. जे अगोदर तुम्हाला माहित नाही, जे previous knowledge मध्ये नाही, that means what new. That is what new means. Now see about this new term new. Say till the date you not know about the history, all things are going to be new. Once you can able to prove it. Now see this plant, I don't know what kind of a plant this is. This is new to me, so I think this will that means what a newness to me. But someone can able to prove it. Oh, this is already in existence, so there is no new about that particular plant or that particular process. So newness. Then non-obvious or inventive step. It should be having an inventive step. If there is a lack of inventive step, then you can't able to claim that the product or process is going to be patented. If suppose the two chemicals are going to be mixed, and the third is going to be derived. third is derived. So during this mixing process or the transformation to third product, so if there is no any kind of an innovative step that are not known to that some other person, then we can able if we will not able to claim for that patent. Then industrial use, this is the most important. Every product and processes must have that utility aspect, must have their industrial application. If it is not used for the industry, someone may going to take your patent from you. That suppose we have patented some product and for the 5 years or 10 years you are not doing anything, you are not setting up any plant or product, or you are not even though lease to someone who produce those product, then your patent can be claimed by the others that it is not having an industrial use, so you may going to use that. Okay, so that is what I am patent. Then about the novelty we talk, then creation of that patent, non-obvious. The things cannot be patented. I think it's we will going to take one slide, this slide. So this is also a copyrighted act. This is a copyrighted invention. So what cannot be patented? There is very interesting thing about copyright. There is one story that monkey, someone is traveling through jungles and monkey has clicked his own selfie by the camera, which is carried by the person who is roaming in jungle. So who will be the owner of that particular picture? Who is that owner of that particular picture or photo? So there is an interesting dispute. So whether the camera, who is owner of that camera, or whether the picture selfie clicked by that particular monkey. So there is very interesting case, and whoever goes to monkey who is not known about that particular selfie, who is the owner of that particular picture, not that person who is carrying the camera. So just like that, there is a various things in copyright too. So what cannot be patented? So section 3(4) and 10(3) in Patents Act 1970 talks about what cannot be patented, what cannot be patented, and Rule 16 tells about what cannot be patented. I have already told you that acts and rules box parallel, acts and rules. When we talk about the act, we should take the reference of rules, and even though the form 2 is also there, what cannot be patented. So there are some absolute ban and some are conditional ban. What cannot be patented. So scientific laws, scientific knowledge, legal and policy, these are the four exceptions we can say that cannot be patented. So what scientific natural laws cannot be patented according to section 3A. According to section 3A, natural laws, and which goes against natural law. So there is an interesting example. So many of you may have heard about perpetual machines. Many are claiming perpetual machines which works without any energy. So it is not going to be happen. It is not going to be happen, which is against natural law. So if somebody is claiming that he made the perpetual machine, so patent office will not rely on that. We will go for that examination on all those aspects. So natural laws, principle, theory, discovery. Yeah, principle, theory and discovery. So section 3C talks about the principle, theory and discovery. So mere discovery of any animal which is existing is not to be patented. Discovery, you have discovered that new animal is there. So which is existing in our nature is only a mere discovery, not more than that. So it cannot be patented. तुम्ही कुठलं तरी नवीन एखादा प्लांट शोधून काढलं, एक्झिस्टिंग नॉलेजमध्ये नव्हतं, किंवा एखादा प्राणी पक्षी शोधून काढला जो ऑलरेडी कोणाच्या एक्झिस्टिंगमध्ये नव्हता, सो इट इज नॉट गोइंग टू बी पेटेंटेड. So there is an absolute ban. Absolute ban. It cannot be patented. Then knowledge. So abstract knowledge, abstract idea cannot be patented. So according to this 3D talks about the new use and property. New use of an existing substance cannot be patented. New use of existing substance. Or a known device, new use and property of substance, things like that. You know about the minerals which are going to be there, and there talks about minerals that are used for making paints, or minerals we can combinedly get it into a third substance. So it is not going to be patented, but there is a conditional plan. Conditional, there is a conditional is there. So what that conditions is, if that particular substances, if they are coming together and delivering an extraordinary efficacy. Just like anything, you can take anything known substances, कुठलेही नवीन substances घेतले आणि त्याचं थर्ड सबस्टन्स असा तयार झाला, तर थर्ड सबस्टन्स तुम्हाला प्रूव्ह करून द्यावं लागेल की त्याची इफिकसी काहीतरी म्हणजे एक्स्ट्राऑर्डिनरी लेवलला आहे. सो इट टॉक्स अबाउट दॅट एनी न्यू फॉर्म और अ न्यू प्रोसेस, एखादा जो फॉर्म नवीन तयार झालेला आहे, किंवा जी प्रोसेस जी नवीन तुम्ही डिस्कवर केलेली आहे, त्याच्यामध्ये इफिशियन्सी ही जी आहे ती एक्स्ट्राऑर्डिनरी आहे. जस्ट पाण्यामधून तुम्ही मीठ ॲब्सॉर्ब करताय फॉर एक्झाम्पल, आणि त्यातून तुम्ही मेअरली 40% तुम्ही ते प्रोसेसमधून एक्स्ट्रॅक्ट करता. जर कुठली अशी प्रोसेस डिराईव्ह केली की तुम्ही 99% एक्स्ट्रॅक्शन आहे, सो इन दॅट केस यू कॅन एबल टू क्लेम दॅट पर्टिक्युलर प्रोसेस ऑफ दॅट प्रोडक्ट. देन अबाउट दॅट legality, plant, animal and processes, 3J, 3I and 3O talks about that legality. What cannot be patented? There is an absolute ban about the plant, animal and processes. There is an absolute ban. Plant, animal, processes cannot be patented. Then literally dramatical, musical works cannot be patented, but it is already covered somewhere in a copyright aspect. There is other laws by which we can able to protect those literally dramatic or musical creations of a mind. So it is going to be patented, is not granted, but copyright can be copyright. Then topography of integrated circuit cannot be able to patent. Even though, then about the plant and animals, then there is one case where the Kolkata High Court has granted the patent for the microorganism. there is a conditional clawback here. Conditionally, if you cross the condition, that means the microorganism is substantially contributing something else to create the new things. Normal microorganism cannot be patented. Just like birds as having microorganism, some food as having microorganism. But in the exceptional case, High Court has given the patent for that particular microorganism, so it is a conditional ban. Then algorithm and computer program can be patented, but due to this with an technical effect. If those programs or software, if they are producing effect in what sense? More than efficacy. It's already boils down to efficacy. How much efficacy is showing with that particular program or with that particular algorithm? So then it can be patented. Then policy. So there are some policy bans. So public order and agriculture. India is known for agriculture as an agriculture country. So agriculture, as related to agriculture, any product can be patented. Agriculture products, plants, and their derivatives cannot be patented at all. And in public order, legal public order. Public order, what it means? Public order, if you are manufacturing a device which can able to harm someone, it cannot be patented. Harm someone. You are making some sword and which can cut someone in a second. Efficiency is very high. It is against morality. It is against morality, even though it is against constitutional. We are having three pillars, three major constitutional acts: 19, 14, 19, and 21. Yeah, these are the basic three brackets. So what 14 talks about and what 19 talks about. So what 21 talks about? 21 talks about the right to life. So everyone is having a right to life. Now, even though in 19 freedom of speech, is it? So freedom of speech is having conditional that the navy or army person cannot able to speak freely. So they are having some constraint. So Article 32 talks about there is limitation. So army person cannot talk in public publicly. Opinion can be, we may have opinion, but having you should have to take the permissions for that. So there are some legal aspect to that public, which goes against the public order, Even though when we talk about the public order, which is in favor of public, if some inventions are going to be in favor of the majority of your stakes, so government may going to take that patent and it can be used for that, say, public welfare, just vaccination. I think previously the corona vaccination is going to be very, we have to pay 1,500 like this, and then some stuff. Even though, so when those kind of invention comes, likewise, so if it is going to provide the major beneficiaries and public, so government can take your patent. Definitely, the government will going to pay compensation for that same. Just like So land acquisition. जर कुठला ट्रान्सपोर्ट आपल्याला किंवा मेट्रोसाठी जर कुठली जागा कोणी गव्हर्नमेंट जर मागत असेल तर ती द्यावी लागते का? सो डेफिनेटली युअर इंटरेस्ट इज देअर, बट इट इज मेजर beneficiary is majority of that stuff. So like then what cannot be patented already we talks many things about that. Then document required to file a patent. So before that, what patent required? First, title. Title should be within 15 words. There is a limitation. Title should be 15 words. Then we require an abstract, preamble first, then abstract. What do you mean by preamble? Constitution has preamble. What is preamble means? आपल्या भारतीय घटनेला एक चेहरा आहे, we can call it a preamble. Preamble is just like a face. What preamble talks about? Equality. Then anybody? See, it is not our subject, but yeah, definitely it is also associated with our today's topic. Anyone? Or we will going to leave and we will now proceed. Yes? Integrity. How many words are there in framework? How many words are there? Which are on basis of that our whole constitution is written. Very interesting topic, but this is not an time and place we have to discuss here, but we have to move further. That see, so law is to guard the things as well as to guard and protect the things, but also gives a direction to the community. Also gives a direction to the community. We are shifting somewhere else, but let us move towards the again that about the patent. What requires to file a patent? So form 1 and form 2. These are the two forms which are going to be required. So what form 1 and form 2 contains? So form 1 contains preamble, then your abstract, then introduction, and after that, if process is there, method, if and lastly the claims. You should have a claims. So claims should be written in a particular manner so that you can able to fence your idea. You can able to fence your idea. Idea or say definitely idea is converting into product. So you are also enveloping that particular idea. So abstract should be within 150 words. There are some certain limitations. 15 words title is required, 150 words abstract is required. Say that is mandatory to fill in a form. Without that, provisional patent cannot be provisionally say publication. Provisional publication will not be there. So and we require a provisional specification. Provisional specification are those specifications which are going to be we will not going to land on that particular specification, but those are our creation. That this is what a dimension of my product, x, y, z, height, weight, length. So this is what your say provisional specification. Then drawings are required. Models are required. Okay. So these things are required to file the patent. Then procedure for filing, say patent in India. So filing patent in India, if possible, we should have a complete specification, and if not, the provisional specification also can be quoted in Form 1 and Form 2. After that, filing, there will be a publication. First, the patent is going to be published, and within a 12 months of the time period, we have to file that particularly complete specification. 18 months of period can be extended, 6 months can be given to file that particular complete specification, and after that there is an examination. After that there is an examination. So there is 180 are number of acts are there. Out of that, from Act 1 to Act 81 is that those acts which will include talks about the grant of that patent, and after 82 to 160, that act talks about the main how that patents are to be maintained after granting. After granting, how that patents are to be maintained. Then there is a post-grant opposition and likewise. So patent search, this is an important aspect. Before writing your claim or provisional specification, or even though any idea is with you, any say product, you have to come into reality, you should take the help of those sites. So these are the sites where you can able to fetch the existing patent which are associated with your domain. तुमच्या डोमेन मध्ये किंवा ज्या डोमेन मध्ये तुम्हाला एखादी आयडिया किंवा प्रोडक्ट सुचलाय त्या डोमेन मध्ये ऑलरेडी काय एक्झिस्टिंग आहे. दिस इज व्हेरी इम्पॉर्टंट. पेटेंट सर्च. So while writing claims, you should not encroach in others' area. Patent search, you can able to search the existing products, existing processes. Then you can fetch the different claims which are already being in existence. Okay. So after patent search, so how to do that search? Then by subject, by keywords, by classification. There is one interesting thing about that patent. That patent can be classified into various categories. Again, this is a very vast things about that patent classification. Then there is patent family, proximity search. We have to search nearby. Then according to your country, then you can able to e-file it. Then we should come up here about that. What should be our roadmap? So what should be our roadmap? So first we can begin with filing application. So Form 1 and Form 2. Just fill up Form 1 and Form 2, and you can take the help of patent agents too. And even though you can able to file your own, you can file it only in 1600 rupees. You can file the patent, and once you file that patent, the patent application only, then it will going to be published in Patent Journal of India. And once it is going to be published, so there are objections going to be live on your claims. तुमच्या जे की मी जे फाईल केले जे काही क्लेम केले त्याच्यावर क्लेम्सवर ऑब्जेक्शन्स येते आणि त्या ऑब्जेक्शन्सला तुम्हाला रिप्लाय द्यावा लागतो. सो इफ यू आर नॉट एबल टू फाईल इन कंप्लीट स्पेसिफिकेशन, the objections can be say you can avoid to that objection by filing that complete specification. ज्यावेळेस तुम्ही कंप्लीट स्पेसिफिकेशन फाईल करता त्यावेळेस तुम्ही ऑब्जेक्शन ते काय होतं तुम्ही त्यातून ऑब्जेक्शन म्हणून बाहेर पडू शकता. जस्ट लाईक वी डोंट नो once we claim something we don't know what is an existing claim. So once it is going to be published, just like landowner, this land is now I have taken the land from this person. You are publishing that ad in local papers and some may have objections on that. So you have to clear those objections. Then and then the matter will be settled. After that, the next procedure is done. So similar thing is there. Once you file a provisional specification, then it is your that particular patent is provisional patent is published. That claims again will be challenged by someone, and if you are not able to answer those, then we'll go to stop at this place. And if you are not able to file the complete specification, then that patent will going to be amended अवसायनात पडतं ते जसं आहे तसं. You will not going to claim it again. Once you file that complete specification, once the objections are you come over of those objections, you can write the claims again. So it will go for the examination. It will go for the publication, and then say after 18 months request for examination, you can go for that examination, and once that examination, then there is first examination report. You will going to receive the first examination report. So it is given by the controller, patent controller. Controller will going to give you a first examination report. So what this first examination report contains? So first examination report contains how many claims are infringing. How many claims are infringing? If you are writing, at least you have to write a 5 claims. You have to write a 5 claims, and there are limitation of pages. There are limitations of pages, number of pages, whatever you are using to draft those claims. There are again the limitations. So now those claims, so examiner controller will go to examine your those 5 claims against the existing patents, and he will going to prepare a report, and he will going to tell you about the how many claims are infringing, and he will going to refer those patents, and he will give it to you. Yeah, he has these 5 claims. Now these 5 claims are infringed by say X patent, which is in Chinese patent, Y which is going to be in US patent, so like that. So this is what FER, that is the first examination report you will going to receive. If you overcome all those, there is hearing. After that, there is hearing in patent office, which is an online hearing. So you can have your own defense for that particular claims, and once he is agree, he will go to accept and have an say advertisement. So here you can means there is a grant, acceptance and advertisement was grant, but after grant 2 there is a post grant opposition. Some may have post grant opposition. So once the patent is granted, not means and you are absolute right to use it. Some may have oppositions, and those oppositions have to be dismissed if those oppositions are going to be, the liability comes towards those who is offensing that particular patent. Okay. So how to obtain the patent? Then term of patent. So there is a 20 years term provided. After that you have to pay the reasonable fees, and again you can able to carry those patent. Then right of patent holder. So this is what the slide which shows about the patent which is granted to me, but if you want an from say publication to grant, So I have filed on 10th of January 2017, and I granted, I got the grant say 15th March 2024. So this is what a time period it takes to grant. So I think that what procedure I have adopted is going to get to know what will going to be a procedure. So now, so form 1 and form 2 is filled. Form drawings are also provided. Drawings and mandatory part of your patent, drawings and model. Then there is a publication. So publication here somewhere in 17 it is published. Once it is published, it goes for an examination purpose. Once the examination is given, then there is an first report of examination. I have received that examination report is replied on say 7/4. Fine. So FER is addressed. First examination report is addressed, and after that, if there is no objection later on, then the patent is granted. How that patent looks? So there is a patent number, patent application number. It is a unique application number by which you can also able to search the patent. Then title, date of filing, then name of patentee, and date of grant. Remember, the date of grant is very important, because after date of grant, 20-year period is started. So this is how the certificate looks like. There is patent number, patent application number, date of filing, and say 10th of January, and this was a grant. From this date, 20-year count is started. From this date, 20-year count is started. Now, how to exit? Exit where? It's a video. are the drawings we can able to produce. You can able to produce the particular model and mention the parts. You can able to mention those parts. Okay. So just like this is a CPM device, continuous passive motion machine, which is able to provide the motion to that particular body parts, body arms. So here, what is the newness? What is the new in this device? So this can be used to the any of the body parts. After surgery, after a joint surgery, this device can able to provide the motions, whatever the post motion required, active and passive. This can be provided. So that is what a newness. There might be question in your mind that there are some other CPM devices are already there, but those are only for a single joint. And one more claim we made, that unique claim. There are various kind of motion. Flexion and extension, these are the basic motions. Flexion and extension. Out of that, circumflexion. This is what I am, flexion and extension. And circumflexion is what? This kind of a motion, circumflexion. So these motions can this can be accommodated with this device. So this is what I mean. Then second about the inventive step. So what are inventive steps? So here the inventive step are mentions like that. If this is the holder, which travels around this body, and which is contactless. So this attachment can be removed. So this makes some steps that which are innovative. And industrial use, this is definitely this model can be produced and can be manufactured. Already prototype is manufactured, and this hence it is proved that there is an industrial application. Then so this is what an MAHESH first report that is produced. So objections are raised. So objections are raised by that particular controller, and there is a response to the objections. Okay. So about the novelty and innovative steps from claim 1 to 2. So this is what a US patent which is infringing to the novelty. So he mentioned that there is a lack of say inventive step, novelty and inventive step. They don't have any US patent होते, एक Japanese patent होता जे की नॉवेल्टीला इन्फ्रिज करत होतं. तर त्याच्यावर आपल्याला ते ऑब्जेक्शन्स आपण ओव्हरकम केले. So definitely I have taken help of patent agent to write, because the language which is they understand or should be written in that particular manner is known by that particular patent agents. जसा आपण एखादा वकील करतो एखादा, बरोबर ना, आपला म्हणणं मांडण्यासाठी, त्यासारखं आपल्याला पेटेंट एजंट हा का हायर करावा लागतो, कारण तो त्याच्या लँग्वेजमध्ये ते बेटर सांगू शकतो. सो दीज ऑब्जेक्शन्स आर ओव्हरकम. Then amended claims are there. Then about the novelty issue, say it tells about fails to disclose and teach, mention or suggest about this guideway 104 claim 1 page 1. So all those objections are overcome come, or objections are say we can able to answer those objections. We can able to answer those objections by means of mechanisms and all those things. So this is what an FER, and you will be able to get the intimation of grant. So now remember, the controller has some powers. Even though the controller, when he is hearing something, so it is having power of district judge. It is having that power of district judge. So whatever we know that there are two suits, civil and criminal. So similarly, if someone wants to challenge the say decision of controller, he can able to challenge it in civil suit in district court. So this is what about the patent and patent law. Remember, the patent law is Patent Act is 1970 is important. Summarizing that, say 1, 2 and 3 talks about what can be patented, what cannot be patented. 1J is known about what to be patented. 3, what not to be patented, what is not patented. Then 5 to 10 talks about the what is the requirement of patent, that it requires an say title, then preamble, then introduction, then your claims likewise. Then 11 talks about the publication of that patent. 11 talks about the publication of that patent. Then 12, okay, till that section 82, till section 82 is about the grant of that patent. And after that, after once it is granted, then the second part comes management, managing those patents, so that that patent can be transferred, even though can be leased, just like we are leasing land. Then that few clauses are related to if the person is going to be deceased. This is that no more. Then how that patent can be transferred to some other person. Then there are some conflicts. If there are conflicts in say about the ownership of that particular patent, so there are some acts are there. So this is what all about the patent law. And if you are thinking about the managing those IPs, then you can able to say few things about the startup. If you want to have a startup, then it not mean that you require a patent. You can able to take a lease from, and even one interesting case is there. If after 20 years there is a grace period for the patent, if that grace period is over, then you can able to start manufacturing that particular product. जर 20 वर्षानंतर कोणी लक्ष दिलं नाही, पॅटर्न मॅनेजमेंट मध्ये हा महत्त्वाचा मुद्दा आहे. जर 20 वर्षानंतर ते पेटेंट्स रिन्यू केलं नाही तर ते पेटेंट पब्लिक डोमेनमध्ये जातं. एनीवन कॅन यूज that particular product or patent, even though if it is beneficial, that product is beneficial to major of the population. एखाद्या मेजर पॉप्युलेशनला जर ते फायदा देत असेल तर तुम्ही क्लेम करू शकता ॲज अन public interest. You can able to manufacture those. There is an interesting case, Cipla against, I think Cipla against one pharmaceutical company there. I don't able to recall those name here, but Cipla is manufacturing one drug, which is very popular and they are gaining revenue. Now, second pharmaceutical company came in picture and he claims that it is in traditional knowledge. So those pharmaceutical or chemical which is in traditional knowledge cannot be patented. So once you prove that this is in existing knowledge or in traditional knowledge, so that patent will be cancelled and you also able to manufacture those pharmaceuticals. I don't think, man, but Cipla against one case. Yeah, disputing. They are claiming that this is a traditional knowledge, hence cannot be. This patent should be withdrawn from them. Right. Once it is in public domain, we can able to manufacture. So there are so many things we can talk about the patent and management of that particular patent. See. लॉ कसा आहे असा दुधारी तलवार आहे फॉर दॅट गुड थिंग्स टू वी कॅन यूज इट फॉर नॉट से फॉर द बिझनेस पर्सन somebody wants to use it as a weapon, you can use it as a weapon. Literally, if you are able to prove it that this is for the public interest, you some may third party can able to file a PIL, public interest litigation. Once he file a civil suit in PIL and proves that no whatever the drugs is manufacturing, so law can take the compensation. He will get compensation, but monopoly of right. What patent provides? Monopoly of right. Patent provides a negative rights to exclude others. Patent provides exclusive right, not inclusive right. Patent काय provide करतं? Exclusive. हे तुम्ही करू शकत नाही. ठीक आहे. So that's it. I think just we have looked about the various product and processes we can able to patent. After that, major acts. We have discussed the major acts, even though not rules have not discussed it, and you are ascertained about what can be patented, what cannot be patented, and if you want to patent something, then what you require a patent search, and you require certain forms to be filled, And what is the basic requirement? Only basic requirements are, at least you should have abstract, you should have particular say introduction and claims. Claims are important. Claims, after that drawing and models. Those are, now it is mandatory in current amendment, drawings are required and models are exceptions. Models, that means whatever the solid models we are using to visualize those things. So models are exception. So these basic things are required. And remember, whenever you are disclosing the things, you should sign the disclosure form. If you are disclosing few things, so you should sign. So once it is in public domain, you can't able to claim the patent. So which is not in public domain. At least you should file it provisional patent. At least you should file provisional patent, get it published. After that, you can able to present a paper, or you can participate in say exhibitions like this. If you have an say abstract idea cannot be patented, business idea cannot be patented. But if it is in a process, if it is in a one kind of a process, and the process, how that process should be efficacy. Efficacy is an important aspect about the process. Chemicals cannot be say patented because it is an existing knowledge. It is an existing knowledge. Okay, we can discuss now. Whatever the questions might be.
Explain about the patent protection. Patent protection.
Once we got the patent, already the protection is limited up to what you claim. What if you are not claiming? See, the angle, included angle of that twin parking is not claimed. So that advantage is taken by someone else, and you will going to lose that. You will going to lose that. Say that is what I say. Best example. You can read that case law. TVS and Bajaj. TVS against Bajaj. Twin spark. It's very interesting. That only included angle, he missed only the wording of included angle, and though included angle is there, specific. I think I'm not recalling those things, but 7 to 12. If included angle is other than that, if it works, he mentioned claim is, your claim can be narrow or can be wide. If you take a wider claim, you can infringe others' claim. If you have a narrow claim, you will going to lose that particular area. You can able to lose that particular area, and someone may going to get that particular area. He can able to tap those area, and he can take your patent away from you. So claim is very important. Claim are just nothing but a fence. जर तुम्ही claim proper draft केला नाही, तर त्याचा बेनिफिट जो आहे, आणि त्याचा बेनिफिट कोण घेईल? आता म्हणजे कंपनीकडे सुद्धा स्पेशल ऑफिसेस आहेत, हे जसे लीगल ॲस्पेक्ट करण्यासाठी लीगल ॲडवायझर असतात, तसं पेटेंट एजंट हे जे आहे हे याच कामासाठी असतात की समोरच्याचं प्रोडक्ट काय आहे, and you know about the business, when we are talking about the business, दुसऱ्याचा बिझनेस एक तर कसा डाऊन करायचा, दुसऱ्याची जी लाईन आहे छोटी करायची, नंतर आपली लाईन मोठी करायची. आपली लाईन मोठी करायची म्हटल्यानंतर डेफिनेटली त्याच्या क्लेम मधून आपल्याला काहीतरी कार्व आउट करावं लागेल. सो क्लेमिंग इज नथिंग बट अ कार्विंग आउट ऑफ आर्ट. क्लेम काय आहे? क्लेम म्हणजे काय करतो? ते म्हणजे हे व्हर्च्युअल कार्ड करतो आणि तुम्ही जर एरिया मिस केला तर कोणीतरी टॅप करेल आणि तुमचा क्लेम कोणीतरी घेऊन जाईल. म्हणून क्लेम शुड नॉट बी टू नॅरो, शुड नॉट बी ब्रॉडर. Broader, there is a chance you will going to infringe the others area, and if it is going to be narrow, some may going to take you because that lost area, that particular area. जसं ते बेस्ट केस स्टडी आहे बजाज आणि TVS. सॉरी ऑन रेकॉर्ड नाव घेतोय ते थोडं हे करावं लागेल, माहित नाही मला त्याच्यावर कुठे ऑब्जेक्शन्स येतील काही जर पब्लिक डोमेनमध्ये तुम्ही जर म्हटलं तर. And subjected to that, this content is taken from WIPO site, WIPO and patent office site. All those contents are from disclaimer. Yeah. So see, there are various courses available on WIPO site. You can take it free of cost. And you can enhance your knowledge. And I think there are various acts and rules. Only these two books are sufficient. These two, Patent Act 1970 and rule Patent Act 1970. This is what I book. Say you can get it from Indian Patent Office or online, and rule 2003, where you can able to study those acts and rules. And remember, acts and rules goes hand in hand. If you are aware about all those acts and rules, you can able to tap various products. Even though you can able to search the product, tap that particular area, create some new product out of that, and you can able to manufacture and have your own monopoly in that particular area. Yeah, anything in your mind about the patents? काय जे काय तुमच्या डोक्यात असेल. मराठीसोबत सगळेच कम्फर्टेबल आहेत, म्हणून तुमच्या ओन लँग्वेजमध्ये you can ask me. काही तुमच्या see, I've gone through that particular processes, so that's why I knew few things, that patents must be must be there full proof, so that you can have very less objections by the controller. Say, who will have to take the objection? Either your rival or a controller. Rival, that means not a rival, is not known to you, but if you are claiming Honda's product, so definitely their people are there to protect their IP. And remember, if it is not in your knowledge, you are manufacturing product. जसं तुम्ही जर हुंडाच्या बाईक जर तयार करायला सुरुवात केलं, त्यांची टेक्नॉलॉजी त्यांना काही काय म्हणतात टायप न करता काय करतात, आणि त्यांना जर लक्षात आलं आणि बाय द टाइम ते विल गो टू रेज द ऑब्जेक्शन, जेवढे प्रोडक्ट तुमचे सेल झाले त्यावर जेवढं प्रॉफिट केलं त्याच्यात सगळ्यात लार्ज पेनल्टी कंट्रोलर तुम्हाला देऊ शकतो. कॉम्पन्सेशन इट इज नॉट अ क्रिमिनल सूट, जे क्रिमिनल तुम्हाला माहिती आहे, क्रिमिनल क्रिमिनल सूटमध्ये काय होतं, जेल, आणि सिव्हिल सूटमध्ये काय होतं की नॉर्मल पनिशमेंट. म्हणजे नॉर्मल, इट्स नॉट ॲज नॉर्मल. ह्यूज अमाऊंट कोणी जर तुमच्याकडे क्लेम केली, तुम्हाला ती कंपनीज त्याला सरेंडर करावं लागेल, म्हणून बरंच काही तुम्हाला त्याच्यात द्यावं लागेल. पण काही मनात प्रश्न असतील तुमच्या, काय जे काय असेल atomic energy cannot be patented. It is against public morality. Defense बंदूक तयार नाही करू शकत, तुम्ही पेटेंट नाही करू शकत. वेपन्स ना अगेन्स्ट 21 आहे 3 त्याच्यामध्ये. म्हणजे नोकरी थोडासा रश झाला आणि काय म्हणतात ना, सगळे काही जे कंटेंट होते ते सगळेच काही मला पूर्ण देता आले नाही, पण थोडा रशवर झाला एका तासात. पण तरीही तुमचे जर काही प्रश्न असतील त्या 10-15 मिनिटात मी ते ॲड्रेस करू शकतो. काही तुमच्या मनात काही जे काय असेल ते मे बी इट मे गोइंग टू बी जस्ट लाईक अ कोर्स क्वेश्चन. मी काय मला नवीन नाही, तुम्ही मला काय विचारू नंतर सुद्धा